All rise. Circuit Court of Rankin County is now in session. The Honorable Dewey Arthur presiding.
All right, please be seated. Let's see. Okay. All right, State of Mississippi versus Carly Gregg, cause number 2024-3416.
The moment the hearing begins, the seriousness of the case becomes clear. This is not just another routine court matter. It's a major felony case moving forward. The court is holding a pre-trial conference, which usually means the plea agreement has been declined.
Please bring the defendant to the podium. All right, we're here by way of pre-trial conference checklist, which means that the defendant has rejected any recommendation from the state. For the record, what was the last recommendation of the state of Mississippi?
Here, the state recommended 40 years in the custody of Mississippi Department of Corrections and agreed to not prosecute counts 2 and 3 of the indictment. Again, there were fines and no contact and things like that.
All right, Ms. Gregg, did you receive that recommendation of 40 years?
Yes, sir.
And it was your choice and your choice.
From this point on, the case is moving toward a full trial, and that carries real risk for everyone involved. Earlier, the state offered a plea deal of 40 years. That alone is a very long sentence. But if the defendant chooses a trial and is found guilty, the punishment could be even more severe. The possible outcome could be life in prison, or a sentence that could add up to as much as 93 years. This is what lawyers call trial risk.
Reject that recommendation.
Yes, Your Honor.
If she proceeds to trial, count 1, what's the potential sentence?
Life.
If the jury fails to affix the sentence at life, what's the sentencing range?
20 years to 40 years.
All right, and count 2, what's the potential sentence?
Between 20 years and life.
All right, she's 14 years old, so if the jury fails to affix the punishment at life, she's facing 50 years.
Give or take, Your Honor, yes.
Okay, and in count 3, what's she facing?
Another 10 years.
Another 10 years. So the jury will either acquit you, or you'll be facing 2 life sentences, or this court can sentence you up to 93 years. Do you understand that?
Yes, Your Honor.
It's your choice and your choice alone.
Turning down a plea offer can sometimes lead to a much tougher result. The big question is whether the defense believes they have a strong chance to win. The judge then carefully confirms that rejecting the plea is the defendant's own choice. This step is very important in court. The judge is making sure the record clearly shows she understands the risks.
To proceed to trial.
Yes, Your Honor.
Have a seat. It says discovery is complete except expert reports from McNaughton experts. I thought I've ordered those be turned over 3 times. Has that been received by the state?
No, sir, Your Honor. And I just, before you walked in, got with counsel opposite and showed them 2 orders that were motions that he granted last time we were in front of you. The order granting our motion to compel their compliance with the mental evaluation analysis, and also the order granting the motion to compel compliance with Rule 17.
If there is a conviction later, she cannot say she wasn't aware of the possible consequences. Next, attention turns to a disagreement about evidence, especially expert reports. The judge mentions that these reports have already been ordered several times. Expert evaluations, including mental health reviews, can strongly affect how a trial unfolds. If these reports are late or incomplete, it can create serious problems for the case. The judge also comments that jurors are paid only $25 per day.
May I approach?
you still intend on trying to offer experts at this trial?
Your Honor, we have an expert that's going to be doing an evaluation. We do not plan on contacting him.
All right. Well,
And Your Honor, just for the clarification, we're aware of the time constraints, and we know that we have to get our evaluation done. Our evaluations happen on Thursday. And the report-
actually, the reports were due a month ago, Mr. King. I signed an order more than a month ago. Now, I'm not going to, there's nothing in front of me to rule on at this time. There's nothing in front of me to rule on at this time. All right. Says that there's some pending motions, anticipated motions, to suppress urine test, and both sides think it'd be 3 days for trial. Is that correct by the state?
Your Honor, I believe it'll take probably a little more than 3 days. But there are additional motions that the state intends to file, certainly some motions in limine.
All right. Other defense?
Your Honor, I expect the trial itself to probably take 4 to 5 days.
All right. I'll remind both sides that these jurors are getting paid a whopping $25 a day. So, y'all drag this case out at your own.
This is a gentle reminder that the court expects both sides to use time wisely. Even so, both the prosecution and the defense believe the trial could last 4 to 5 days. That suggests the case will involve expert witnesses, detailed testimony, and complex arguments. From here on, the focus shifts to preparation.
However, I'm going to give each side plenty of time to try your case. All right. All motions under Rule 16.1, the motion filing deadline is this Friday, August 30th, 2024. Under Rule 34.1, the Mississippi Rules of Criminal Procedure, all motions must be in writing and must contain a concise statement of the precise relief requested and must state the specific factual grounds and specific legal authority. Failure to comply will result in the motion being considered procedurally abandoned or waived. Responses must be filed in writing before the close of business Wednesday, September 4th, 2024, or the motion may be considered confessed. Reply to any response may be filed if desired before the close of business on Friday, September 6, 2024. Under Rule 34.2, you must be in court on Tuesday, September 10th, 2024 at 9 o'clock for hearings on pretrial motions. All jury instructions must be pre-filed before the close of business on Friday, September 13th, 2024. This court will not entertain a request for jury instructions either party failed to pre-file unless there is good cause shown. Additionally, an editable copy of all instructions must be emailed in Microsoft Word format to sbutler@rankingcounty.org. All right, I need this attorney for the state. I've already signed off on this.
Yes, sir.
Oh my God, yeah.
Do I need to put the additional motions?
No, as long as the motions are filed by the motion filing deadline, the court's going to consider all motions both parties file. As long as they contain a legal basis and, some case law. All right, anything further from the state?
All right, I think the only pending matter, and this may be something that we address at the pretrial conference, is the defendant, and I don't have it in front of me, I think filed a motion to transfer to youth court that we've never heard.
You want to hear that on pretrial conference day, or do you want to hear it today?
Pretrial conference day.
All right, the court will hear that matter on pretrial conference day. Anything further from the defense?
No, Your Honor.
Best of luck to both sides of the defendant.
There will be motions, hearings, and planning for jury instructions. All of this happens before the trial even begins.
Court will be in recess for 15 minutes.